Okay, over here, please.
My question is about the present CA for education funding. I recently read that the Senate watered it down a lot, and I'm not sure how the heck I vote on it, the way it's worded right now. I was just seeking advice, and is this true that it has been watered down so that it gives more authority to the court than the House had originally meant for it to have?
Actually, Representative Sorg. Well, I know, wait a minute.
What the Houses want to do, what the House version did was to get the court out of entirely, because the court's proven that it can't be relied upon to be an impartial arbiter of what the Constitution means. The Claremont decisions were so obviously politically motivated that the House is just impatient with them and left them out. But, you know, habits are hard to break, and the habit of dependence upon what the court thinks about things is hard to wean legislators off of, and so the Senate backed down and put in language that would enable the decisions of the legislature to be reviewed for constitutionality by the court, and would leave the court back in with a lesser standard of review, but nevertheless leaving them in there. We just don't trust them anymore. You know, we can say, well, we reduced the standard of review from strict scrutiny, which is the most intrusive, down to something called reasonable basis, rational basis. But so then we would pass what we think was a rational law, but then the court could just say, well, it's not rational. And there we are, right back with Claremont 16, Claremont 17. It just wouldn't solve the problem. And it's better not to fool the Constitution at all than to do something that enshrines the constitutional crime committed by the court in the Constitution. That would be worse than the disease we have right now.
So in other words, we shouldn't vote for it?
I wouldn't vote for it the way the Senate changed it, no.
Okay, that's
Are we
what
talking about CSR 12 or are we talking about CSR
12.
Yeah, I would like to make this observation, that is that, first of all, Representative Sorg has used the word constitutional crime a couple of times. And I have been looking for a phrase that would describe it. Because certainly Claremont 2, there's no language. You could read the parts of Article 83 1,000 times and never find the power. I was talking to you earlier when I was speaking to you about the very nature of power is that if you grant an entity pretty much arbitrary power, it will do as it wishes, which is what, and it's reflected pretty much in the Claremont decision where there's no foundation whatsoever. Now, the problem for legislators at the moment is the House passed an amendment which sort of got us a little ways towards perhaps recapturing some of the power, but was not really a complete remedy for Claremont 2. But what is currently before us is some language which some people think establishes the responsibility on the part of the state government to actually maintain, more or less, you have to maintain a system of education. And some of us are cogitating on whether or not there was ever, well, in fact, I don't believe there was ever language in the Constitution that would, that said that the state should establish a system of education. Now, certainly the legislature has the power to create a school system and do anything it wants. It's all the representatives come together, they come from the towns, they can make all laws that they see that are appropriate. So they certainly have the power to do it. But some of us struggle with the idea that it was somehow an inherent obligation. So myself, I'm struggling with that present language. I don't know what I'm going to do with it. I have an idea, but I'm not going to tell you. But there's a terrific amount of pressure being put on members of the House right now to vote for this new so-called leadership amendment that presumably would remedy or somehow put the Claremont decisions to rest. And it's something I think if you have strong feelings about it one way or the other, you really ought to be talking to your representatives. Help me arrive at a decision. As I said, I'm not going to reveal to you what I think I'm going to do just yet. But some people certainly believe that what it does, this new amendment, is establishes responsibility where there was none before.
Representative Ingbretson?
Yeah, if you don't mind, I'll just add one comment. It isn't going to answer your question, but when we sat before several lawyers, they're trying to actually convince the hardcore, these kinds of guys, not me, of course, but they're trying to convince us that we should write this, we should accept this, the governor's version or the Senate's version of this. And the speaker told them, he says, well, all right, you guys come up here and try to convince them. Of course, they had no chance because, and my argument about all this stuff is, you mean, and this is my question, which they giggled instead of answering. I said, you mean 3 guys sitting on the Supreme Court can change the meaning of the Constitution by redefining words, and we have to go through an amendment process to get back? No. I mean, to me, it's the most serious abuse of a person's position in government that I've ever seen. And frankly, the reason I'm here for the same reason as Representative Sorg is here, is the Claremont decision.
I can't help myself. Can I say one more thing? I read Claremont 2 the day it was issued, in December 17, 1997. I read it, I bought a copy of the Union Leader at the local general store in Enfield, and I read it coming down the interstate as I was driving from the State House. And by the time I got to Bridge Street, which is where I make a right to get up to the Capitol, I was so incensed. I'm surprised I could make it the rest of the way without striking some other vehicle. And because when you read, and you've heard this all, you read the language, you can't find any basis for it whatsoever. So I'm taking an interest in the subject and speaking on it a lot, going around the state and trying to debunk these decisions. When you take the lead on something, people will come to you with stories. And 8 weeks ago, I had a very impeachable member of the state government tell me that Justice Johnson was one of the 3 members, three of the 4-member majority who created Claremont 1, told this person that he had finally decided he was going to run for office because he'd retired as a judge, he was off the court, because he was so incensed that the legislature had imposed an income tax, which he said was the fundamental basis for making the Claremont decision. Now wait, that's not the worst of the story. 10, 12 years ago, I knew a fellow who was an intimate with Justice Brock. And Justice Brock told him the same thing. This is 10 years ago. And I had a good friend, my best friend in the legislature, was like this with a selectman in the North Country who was happened to be a close friend of Batchelor. Justice Batchelor, who was another member of the deciding court. And Batchelor told that selectman the same thing. And when, 12 years ago, we tried to get the selectman to come and testify before the impeachment proceedings, to just simply get another message on it, to basically gin up an understanding on the part of the legislature of what happened here, this constitutional crime. So 8 weeks ago, after knowing, and in fact, let me back this up, Governor Sununu said he knew 2 of the justices had conspired to create that decision. I told him a week ago that there were 3. So you have, now this is like secondhand stuff, right? But when you get 3 stories randomly from people, you have to conclude that everything you thought about the decision was true, which is it's made of whole cloth. It was a constitutional crime. So the question, some of us, let me just keep mulling over our heads, is what do you do when you are confronted with a decision which is not generated by a court that is as impartial as a lot of humanity will admit? What do you do? And especially when you can't reach down and get testimony that will allow you to do something drastic, and particularly when the principal players are now off the court.
You got 1 more minute. Questions over here, please. Eric or John? Don't mean to cut anybody off, but I'm sure everyone gets at least 1 question.
This year we gave courts extra money so that they could put in call center and video conferencing so that they could bring, have the men that all women dedicated crimes coming before the court and while they're still at the jail rather than being transported. If we've got all these problems with the judiciary, why don't we just cut out their funding?
Anyone stands in that?
You need a legislation that's willing to do it. We have never had one. You have to look, you and I have to look to the other members of the House and Senate. The will isn't there.
Over here, please. And Tara, if you stand by.
I want to say something to that, because, I mean, it's one of my favorite lines. There is a voter's guide in the Constitution of New Hampshire. I actually read it earlier. It's in Part 1, Article 38. I flipped through here. I told you, we're supposed to recur to the fundamental principles of the Constitution, constant adherence to justice, moderation, temperance, industry, frugality, and all the social virtues. The people ought, therefore, to have a particular regard to all those principles in the choice of their officers and representatives. When you're voting for people to run for office, the questions you should be asking them should lead you to know, do they know their Constitution? Are they frugal? I love the middle one, moderation. To it. Moderation and temperance. Personal life counts. There's a voter's guide there. It tells you how to send the right people up to administer your government for you. And if we have people up in Concord who aren't willing to stand up to the court, who aren't willing to pull the legislative purse strings, well, the ultimate responsibility lies with the people who sent them there.
Representative Twombly, we have reduced the budget of the courts in the past. And what was the court's response? It was to suspend jury trials. That's a fundamental right. The court suspended jury trials rather than to take money out of their internal operation system. That's the way the court responds. You have to ask yourself, is that what sort of court is that? That would suspend jury trials instead of going back and restructuring themselves to little things being.
Yes, thank you.
Okay, all right.
I served in the 1984 CONCON for the Constitutional Convention. One of the most
Can everybody hear the question?
No.
One of the most enlightening experiences of my life is serving in the Constitutional Convention for New Hampshire. It was the last one held because the one before us had put in place an article to allow the legislature to do constitutional resolutions. Ever since the legislature has got that, they have never called back for another CONCON. I believe we should go back to having a CONCON every 10 years.
Okay, what is your question? Who is it directed to?
Why hasn't that bill been introduced?
I think the, excuse me.
You talk about power, Paul. Take away power from the
Representative
legislature.
Itse will address that.
That question, well, first of all, there was never a requirement to have a constitutional convention. It used to be that you had to have a question as to whether or not there should be a convention on the ballot every 8 years. When the people gave the legislature the power to introduce constitutional amendments by resolution, they lengthened that period to 10 years. The question as to whether or not to have a constitutional convention must be and will be on the ballot this coming fall. It's there every 10 years. I too agree that it is safer to have a body independent of the government rather than the government itself proposing amendments, particularly when the issue is trying to restrain the powers of government, because the government is loath to restrain itself.
Wait, there's one thing you need to consider. The amendment to 72A, which created the Supreme and Superior Courts and made them inaccessible to the legislature. All of those amendments, that one, 66, 73A, all came out of constitutional conventions. So with the idea that a CONCON will produce good ideas is, you have to consider that.
GrokTV.